The question is, I have a U.S. citizen child that wants to petition for me. How can I get a green card based upon that? That's a pretty packed and complicated question, but trying to break it down somewhat, it comes down to the following. First of all, having a U.S. citizen child in certain circumstances may help. That child must be over 21 years of age, not over 18 years of age, in order to file for a parent. Oftentimes people believe it's the age of majority, which is 18, but under the immigration law, it's 21 years old. Now, if the parent entered the United States unlawfully, unfortunately my answer is often yes and no. That child can petition for you. As the parent of a U.S. citizen, you're eligible for that child to file a visa petition. However, having entered the United States unlawfully, an individual is not allowed to remain in this country in order to get permanent residence. They would have to leave the country in order to do that. Leaving the country would subject the applicant to what's called a 10-year bar. That's the penalty for having been in this country unlawfully. The way to overcome that 10-year bar is by having what's called a qualifying relative, or a spouse or parent who is a U.S. citizen or permanent resident. So the situation we get into oftentimes is an individual comes to the country, they have a child who's now 21 years of age, and that child can petition for them. However, the individual does not have a U.S. citizen or permanent resident spouse or parent. So unfortunately, having that child only gets you about halfway down the road. If in fact an individual entered the country lawfully, in other words pursuant to a visa, a visitor visa, a work visa, or whatever type of visa, despite the fact that that visa has since expired, and if you have a child who's over 21 years of age, that child can petition for you and you become eligible for what's called adjustment of status, or being able to get a green card in the United States without having to leave. The differences between being able to file for what's called consular processing or adjustment of status, which means filing for a green card without having to leave the United States, are fairly complex. We'd be happy to review your case here at the O'Brien Law Group. Come see us, we can review your case, we can review the possibilities and let you know if in fact you do qualify for one of these forms of relief.